while the defense has tried to make the case that George Floyd's death was caused by his drug use. You would think that during his 2019 arrest, where he allegedly consumed controlled substances, he would have presented at least some of the same medical symptoms that he did under Chauvin's knee.
You indicated that his respiratory effort was normal, correct?
Correct.
He was not in respiratory distress, correct?
No.
His blood oxygen level was normal, right?
Correct.
His pulse was normal, correct?
Yes.
His heart rhythm was regular or normal, right?
Correct.
He didn't stop breathing.
No.
His heart didn't stop.
No.
He didn't go into cardiac arrest.
No.
Back with me are Katie, Phang, and Joyce Pham. So let's go through it. I want to start. This is cut two for my producers. Let's start with Barry Brodd, who was one of the experts that was called by the defense. He actually is an expert witness who's, you might not remember him, but you'll remember the case that he most famously testified in. This was the Laquan McDonald killing in Chicago, in which he testified that it was a legitimate use of force to shoot Laquan McDonald 16 times. Officer Van Dyke in that case was convicted of second-degree murder and aggravated battery. He shot a man who was running away 16 times. Barry Brodd thought that was a perfectly fine use of force. Here's Barry Brodd attempting to explain how keeping George Floyd in his prone position with 91 pounds of downward force on him was not use of force at all because it doesn't hurt at all.
The maintaining of the prone control to me is not a use of force.
Why is it not a use of force?
Because it's a control technique. Without it, it doesn't hurt.
I need to ask you if you believe that it is unlikely that orienting yourself on top of a person on the pavement with both legs is unlikely to produce pain?
It could.
If this act that we're looking at here in Exhibit 17 could produce pain, would you agree that what we're seeing here is a use of force?
Shown in this picture, that could be a use of force.
Okay, Katie, you're here to explain the defense side of this. What?
Yeah, no. I mean, you know, the defense failed today. Brodd was unlikable. I don't know why the defense put him on, other than maybe they couldn't find anyone else that would come and testify as an expert on behalf of Derek Chauvin at this trial. He clearly failed at the Laquan McDonald trial. So, I mean, I don't know if his track record was so good. What was really critical about this expert today, Joy, is that he was trying desperately to show in a very clinical way that use of force has to be done, you know, compliant with police procedures, et cetera. The problem is the defense must assume that the jury's not paying attention, because we heard from the actual guy, Lieutenant Mercel from the Minnesota Police Department, who testified for the prosecution, who said that that restraint technique that Derek Chauvin used is not taught by the Minnesota PD. So we already have the person who's actually in charge of everything, including the chief of police, saying, we don't condone this, like we don't authorize this. And the other critical mistake that was made today by the defense was through this guy, Barry Brodd. Brodd said, you know what, you have to look at what the reasonable officer was doing, meaning we need to put the jury in the shoes of this officer so this officer can you know, the jury can feel whether or not and determine whether or not this officer acted reasonably or objectively. Here's the problem, and Joyce would agree with me. As lawyers, is something called the golden rule. You are not allowed to ask the members of the jury to put themselves in the shoes of the party. That's a mistrial, right? So what's critically wrong with this argument that they're doing? If you ask the jurors, any of these 12 jurors, to put themselves in the shoes of Derek Chauvin, none of them are ever going to say that what that cop did was reasonable, objectively, subjectively wasn't reasonable. So that was a major mistake, because none of those jurors are going to say that 9 minutes and 29 seconds on somebody without a pulse is something they would ever do as a reasonable officer.